Today we're covering contract performance and contract discharge. This chapter explains how contracts are completed, how they end, and what happens when something goes wrong. Let's break it down step by step. So, first three important terms. Contract performance, which is when a party does what they promised in the contract. Then we have contract discharge. This means that the contract is legally ended and both parties are released from their duties. And then we have the condition. A condition is a future event that affects whether a duty must be performed or can end. So, there's types of conditions. There are three types actually in contracts. One, we have the condition precedent. This happens before performance is required. For example, you must pass a test before getting a job offer. Then we have the condition subsequent, which is this happens after a duty has started and ended. So, for example, insurance ends if fraud is discovered. And then we have concurrent conditions. The last one. Both parties perform at the same time. For example, you pay for groceries while the store gives you the food. Okay, now let's look at substantial performance. Substantial performance basically means when a party has completed most of their obligations in good faith. Even if there are small mistakes, the contract is still considered performed. Like Missing's example with the painter, painting the house but forgetting to put the products and like the furniture back. Okay, so what are the requirements for substantial performance? Well, the actions the party performed have to be acted in good faith. The performance is very close to what was promised, and the essential purpose of the contract is still achieved. So, performance to satisfaction. Some contracts may require performance to satisfy another person. If the contract is personal, like art or custom work, it must actually satisfy the person. Otherwise, courts use a reasonable person standard. So, material breach. What's a material breach? Well, let's define it. A material breach is a serious failure to perform a contract. It is more than a small mistake. It allows the other party to stop performing, and the non-breaching party can sue for damages. So, let's look at discharge by agreement. Contracts can end when both parties agree. So, first way is mutual rescission. Both parties agree to cancel the contract. Novation. A new contract replaces the old one, sometimes with a new party. Settlement agreement. The parties settle a dispute and replace the original contract. And accord and satisfaction. Accord is basically the agreement to accept different performance, and satisfaction is the actual completion of that new agreement. So, the discharge by operation of law. Sometimes the law automatically ends a contract. One way could be impossibility, which is performance becomes impossible, like destruction of the subject matter. Second way is the commercial impracticability, which is when performance becomes extremely difficult or expensive due to unexpected events, such as like the Strait of Hormuz, for example, being blocked. And then for number three, we have frustration of purpose. This is the reason for the contract no longer is existing. And lastly, we have bankruptcy, which is a legal process that discharges most debts and obligations. So to summarize, contracts end through performance, agreement, breach, or the law. Understanding discharge helps you know when obligations are truly finished and when they are not. Thank you, and have a good day.